I think we are live. Yeah, I see it.
Is
Okay,
it?
great. Yes, I see it. I see it. There might be a slight lag. Great. I'll start again. Hi, everybody. My name is Angie. I'm a housing specialist here at Housing Court Answers. We're so excited to see everybody from so many different organizations that we work alongside with. I'm joined today and I'll be presenting with.
Hi, everyone. My name is Adriana Beckford. I am also a housing specialist here at Housing Court Answers, and we are very happy to be joined by you all today.
Okay. So yeah, we're going to be taking turns as we go along the presentation. You guys are welcome to drop questions into the chat as we go along, but we'll also be taking them at the end of the presentation. We will be sharing the presentation as well, so you don't have to process everything in this moment. Yeah, so it'll either be on the website or we'll send you guys an update as to how we'll share it. Okay, so let's go ahead and get started. Great. So who are we? Housing Court Answers, if you don't know who we are a nonprofit organization that works alongside the Housing Court. We have Housing Court in our name, but we actually don't work for Housing Court. We do a number of things to help advocate for both tenants and small homeowners. We explain housing court procedures and tenants' rights, and we do this in two different ways. Through a free hotline that's open Monday to Friday from 9 to 5, where we take questions, and through information tables. We literally have a table at every housing court, with the exception of Staten Island, where we answer questions in person, and we also help fill out court forms. We help folks request court dates, ask for extensions. We refer them to rental assistance programs. We do a number of things. Oh, it looks like we have folks in the waiting room. Yes. So the information table is open Monday to Thursday in the Bronx, Brooklyn, Manhattan, and Queens. So the only place we're not located at is Staten Island. Can we go to the next slide? Okay. We have our hotline again that's open Monday to Friday, 9 to 5. The number is on the screen. We speak English, Spanish, French, and Bengali, although we also have access to a language line so we can communicate with folks in any language. Disclaimer, this training is a general overview of housing court and housing court procedure. It's not legal advice. So the one thing that we're not are attorneys. A lot of you guys have access to attorneys or you work in the legal field. That's not actually something we do. This information is meant to apply only to residential tenants in New York City. So we serve the 5 boroughs. And lastly, a person's immigration status does not change their rights in housing court nor their tenants' rights. Okay, so how is housing court working now? A lot of things changed during COVID and then after COVID as well. We're mostly back to pre-COVID systems, but a few things remain. So housing court hearings are now mostly in person, with the exception of the Bronx, where the first court date is an intake for an attorney. So there is an interview process that happens virtually where folks they get their information taken down so an attorney can contact them if they are able to take their case. So in the Bronx, folks can attend by phone or through a video conference for the first court date. The court can grant permission to litigants to appear remotely for those with disabilities, and I'll drop the link into the chat. But basically, folks would have to get in contact with the ADA clerk to ask for an accommodation to be able to appear virtually. The court now relies on e-filing rather than paper filings, although unrepresented tenants and landlords can use paper documents. So let me drop in the chat the link so that you guys can refer folks to apply for ADA accommodation. You can do it in a number of ways. You can call a phone number for the ADA clerk, although it is notoriously kind of hard to get through at times. So we do recommend that you try calling and also sending an email. You can send an email to the ADA clerk. Great. So there are a number of online systems that are actually public record. Anybody can access them. We use them every day. So the first is NICEF, which is the court's e-filing system. On NICEF, you can access court documents for a case. You could use an index number or a person's name to find their case. You would be able to access things like the petition, notice of petition, eviction notices, and so on. The second useful system is eCourts, which is the court's online calendar. So on eCourts, you can access court dates. You can figure out when a next court date is, what room, what time, and you can also see all previous court dates as well for an entire case. HP actions and illegal lockouts are things that tenants do on their own. They file these things themselves. So tenants don't have to use and probably won't be able to use NICEF to file anything if they were to sue for violations or harassment or for an illegal lockout. Oh yeah, sorry. So if a tenant doesn't consent to e-filing, notices and everything must be served in paper form. Right to counsel for tenants. So all tenants in eviction cases are scheduled for an intake as the first court date. So that first court date is automatically adjourned. All that happens on that date is folks are interviewed to see if they both qualify and to have their information taken down so that the law firm that is assigned to do intake that day can reach out to them if they're able to take their case. So the right to counsel law covers tenant households' income that earn 200% of the federal poverty line or below, and then also tenants who are 60 years old or over. So you have to be one of the two, maybe both, to be able to qualify. So when we break it down, being 200% under the federal poverty line comes out to about $30,000 or less for a household of one and $62,000 or less for a family of four. Because of capacity problems, not all eligible tenants will get legal representation. So this is something that we get on the phone a lot, like we have a right to counsel, so what's happening? Unfortunately, we do have to be the bearer of bad news and explain to folks that not everybody is going to get an attorney. There are different ways to get referrals, but there are some tenants that will have to navigate the court system on their own. Okay, so we're going to start discussing the different types of cases in housing court. So there are four main ones. The first two are eviction cases. The first is the non-payment, which is an eviction case that is filed by the landlord to collect rent. So something we like to say, if you can pay, you can stay in the apartment. That is the premise of the non-payment. Holdover cases are eviction cases that are filed by the landlord to remove the tenant for some reason other than the rent. So really the landlord there is trying to get possession of the apartment. The third is the HP action. So these are cases filed by tenants or HPD to get bad conditions fixed or to stop harassment. You can do one or the other or both. Again, tenants are doing this on their own. So we actually help folks fill out the forms at the court. The court provides the forms and then the court also provides a guide. Sometimes it can be a little hard to understand, so we help folks start these cases. And then the fourth is the illegal lockout. Cases filed by tenants, roommates, licensees, etc., who claim they have been illegally evicted. A marshal didn't actually do the eviction in order to get back into the apartment. And the illegal lockout is also filed pro se by the tenant. What if the non-payment is a frivolous lawsuit? What to do? Adriana is going to go into non-payment a lot, and it starts with the answer. She'll go over this, but there are ways to bring up your defense when there's a bogus non-payment being filed against you. Okay.
All right, sorry. So we are going to go into, like Angie said, we're going to go into each case in depth about what these cases are, what these papers look like, and the steps that tenants should be taking when they get these forms. So the first one we're going to talk about is non-payment cases, where, as she mentioned before, the theme of it is kind of if you're able to pay, you can stay, right? So the landlord is suing for non-payment of rent that they believe is to be owed. Now, in a non-payment case, there are defenses that tenants have, which we're going to take a look at some of the list of defenses in a second. But essentially, what these defenses mean are any reasons that they feel either they don't owe, or reasons as to why they do owe, right? So for some people, they have already paid what was owed to the landlord, but by the time that they filed the case against the tenant, it didn't correlate, right? So that would be a defense for the tenant that all the money has already been paid. So in the very, very beginning for a non-payment case, the landlord is not allowed to just take the tenant to court. There's a procedure that must be followed. So that procedure starts off with a 14-day rent demand. So essentially, this rent demand says how much the tenant owes and that they have a 14-day time window in order to pay it. Most of the time, if the tenant can pay what they owe in those 14 days, then there's no case ever started and it's resolved. But if 14 days does passes and that tenant is not able to pay what they owe, which is most of the time the case, then at that point in time, the landlord will start court papers against this tenant, and they will receive what is titled as the petition and notice of petition. Okay, and again, we're going to take a look at what these notices look like in a second. But essentially, the petition and notice of petition will usually state a few things. So first, it usually will describe the landlord, that they're the owner. They will describe the tenant, if the tenant is a resident of the apartment or not. And then they usually will list the amount owed. So sometimes, especially since there's a time frame in between when the tenant gets the 14-day notice and when the tenant gets the court papers, there might be a amount difference, right? So the tenant may have owed a less amount when they got the rent demand and they owe more now at the time of starting the case. So that amount owed will be on the petition. And then it usually will also tell the tenant that they have a 10-day time frame to put in an answer with the court. Okay. In order to file this answer and let the court know of their defenses, again, the tenant must physically come to the court to put in an answer. Unless they physically can't come for some reason, that might be medical, which is what my colleague mentioned of doing an accommodation to do an answer. But if they are able to come to the court, they have to come do that answer, which again, we're going to take a look at in a second. So this is an example of a 14-day rent demand, okay? So a lot of the time tenants get this and they automatically think, oh, I have an eviction notice. So this is a rent demand where the landlord is here, if you can see in the middle, basically stating how much is owed. And usually they will state for the months of which the tenant owes, which is helpful because if the tenant knows that they've paid everything, the tenant can then take their correlating rent receipts for that amount to kind of combat the amount, right? So it's helpful when the landlord lists the months of which they owe as well as the total. So again, usually there's some language in here that says you must pay by 14 days or vacate the premises, which again, sometimes gives tenants that indication that they're being evicted, which they're not. The landlord is giving them a 14-day time window to pay. And if they are unable to pay in that 14-day time window, then usual legal action is started, which is the actual court papers. So this is an example of what those court papers will look like. So I believe this is an example of the petition, in which we mentioned the petition will state a few things. So if we look up top here, this is blocked out because this is a real example. But up top here, this is one of the most important things to identify once the tenant gets those court papers, and it is that index number. So the index number is how the case is identified. Anytime the tenant comes in contact with anyone regarding their case, they're going to be asked for the index. So usually we suggest take a photo of the index number or just have your papers prepared when you're calling us or calling any other agencies or even the court. So that will usually be at the top right of the court papers that the tenant receives. Down here, again, usually will list the amount that the tenant owes. So it will have the total. And then also there's usually a breakdown again of the months that that tenant owes. Okay. So again, it's very important the tenant identifies this part of the papers, because if they believe that they don't owe anything, or if they believe the amount that they're being sued for is higher than what they actually owe, this right here can help them to do that math, right? If they're telling the court, I don't think I owe this amount, they also need to be able to show to the court what they do owe, if anything at all. The petition is also helpful because here in this section, usually around number 7 or number 8, it will list the type of housing in which the tenant lives in. So in this example, the tenant is a rent stabilized tenant. If the tenant lives in a private dwelling, if the tenant lives in a market rate apartment, all of those details will usually be around number 7 or number 8 in the petition. So that also helps for the tenant to know the type of housing that they're in. Now, this is an example of the second part to those court papers. So we just looked at the petition. This is the notice of petition. So the notice of petition sometimes has different information. Again, on here, it will let the tenant know that they have a 10-day time frame to go answer the papers. And if they don't answer those papers in 10 days, the landlord might put a judgment in against them, which means they would be at risk for receiving a marshal's notice. This page here sometimes can be a little misleading as well, because sometimes it has some outdated information where it would say something like, call Housing Court Answers to get referred to an attorney, or to get a free lawyer, call this number. Unfortunately, that's not how it works anymore. The tenant has to go answer the papers first, get their first court date, and that would be the road to possibly getting an attorney. So if you have any clients that they just received the court papers, it is important for them to understand that. Again, on here, it will say, call this number for a lawyer. And then we get all those calls where the tenant is like, well, they told me to call you for a lawyer. So that's important for them to know is the process. They do have to physically go respond to these papers, so they can get their first court date, and they can also have their shot at trying to get an attorney. Again, this is the page that I was mentioning here where it would say, like, for legal help, call this phone number. And also here it informs them as well if the tenant is homebound due to medical reasons, or they have some sort of disability that prevents them from physically coming to the court, they can give ADA a call here, which we do suggest doing as soon as possible. Okay, so this is the last page that the tenant will usually receive, letting them know the resources they have available. So here now we are taking a look at an example of the answer form. So some courts do things differently. Some courts will give the tenant a copy of the answer form to look at, to mark their defenses, and then they come back to the window to give it to the clerk. And then some other courts will have the tenant just come to the window. The clerks will usually go list by list. Do you believe you were served properly? Yes or no. Do you have any repairs in your apartment? Yes or no. And depending on the tenant's answer, they will mark it in the court system. And then they will print a copy and give it to the tenant. So every court does things a little bit differently. So the tenant will just come to court with their papers, let the clerk know that they're here to answer, and then they will go through the answering process. So again, here with looking at the answer form, we get a look at some of the common defenses. Again, a lot of the time, sometimes the tenants offer to pay the rent to the landlord and the landlord blocks them from paying. Sometimes tenants have repairs in their apartment and that's why they're not paying the rent. So things like that, the tenant will basically mark it off or let the clerk know what their defenses are. If there's anything that's not mentioned on the answer form, like let's say they have a pending one-shot deal, or anything else that's not mentioned on here, they can let the clerk know, and the clerk can usually indicate it on the answer. So here, I'm gonna read one question that is in the chat that says, what should you do if landlord uses an accounting system to false claim non-pay, and if these non-pay emails have tons of error? So again, that's why it's important for tenants to have their own proof of payment. If you are paying via money order or check, make sure you have a copy of that. Or sometimes the management office will usually make a copy and like kind of write a receipt for you. Or if you make payments electronically, make sure you can take a screenshot and have anything printed out showing when you made those payments. So just using the ledger that the landlord is saying that you owe, and then use your proof of payments to kind of coincide with that to see what you actually do owe, again, if anything at all. Okay, so that was the beginning stages of a non-payment. Now we're going to move into, you've answered, you got your first court date. Now what comes next? So once the tenant gets their first court date and they file their answer, the clerk will give them a copy of their answers, and that first court date will usually be printed on the bottom in bold letters. Now, that first court date is extremely important for the tenant to appear to, because that is their opportunity or their chance of possibly getting a free attorney. So usually how it works is the tenant will go to that courtroom. They usually will give the tenant an adjournment, which means the tenant will get another court date. And then the tenant will go to usually a separate room to be screened by the attorneys to see if they qualify, and then if the attorneys are able to take their case. Usually the landlord will be notified of that first court date as well as the second court date via NYSEF, which is that electronic filing system that we talked about in the beginning. So it can be via NYSEF or via eCourts, so that the landlord knows when the next court appearance is. Now, again, it is extremely important that the tenant is at the court and their courtroom at a reasonable time. So all of the housing courts do have security where you do have to go through before getting to the courtroom, as well as especially if the court date is or the court appearance is in the morning, like at 9:30, there is usually a line outside the court. So it's very important that tenants allow themselves time to, get to the court early, go through security, wait on that line, and then make it up to their courtroom at a good time. Again, this is also usually where having that index number is going to come in handy, because when you get to your courtroom, they usually will have in like a glass display, a list of all the cases happening in that courtroom for that day. So the tenant can, identify their index number, find their name, make sure that they're in the right place. And then usually let the clerk or let the court officer know that the tenant is there. A lot of the time, tenants will just come and sit down and not let anyone know that they're there, which is a problem. So make sure that they check in, and then just have a seat till you're called. Okay, great. Okay. So now just a few identifying factors of who is in the courtroom at this time. Of course, there will be the judge. The judge is usually in a elevated bench, and they are like, as soon as you walk into the courtroom, that's like usually the first thing that you see. There will also be a court attorney there. Okay, so this attorney is working for the judge, but they might assist you in settling your case, right? So if you have any questions about like a legal term that is in your papers that you don't understand, or you're a little confused on the process, the court attorney sometimes can help with that. And then there's also a clerk that will help to keep track of those papers and the court's calendar. And they usually will work alongside the court officer to make sure there's order in the courtroom, and that the court dates are moving along. So most likely the clerk will be the one giving the tenant that adjournment. Okay, they're going to check the calendar, give them that new court date. They usually will write it down for the tenant of like when the new date is, where you're going to go. Usually it's like a orange or a yellow piece of paper. It's pretty small, but the clerk will be the one doing that. Okay, so just so that the tenant can identify who is there in the courtroom. Now, for a non-payment case, there are a couple different possible outcomes. So usually the goal of a non-payment case is to come to some sort of agreement regarding how much is owed, when that amount will be paid by, and any other factors that's a party of this case. And usually that agreement is called a stipulation. So that stipulation is a written agreement that is usually signed by the tenant, by the landlord and their attorney, and the judge also signs it. But this usually gets done after both parties try to talk and agree to something with each other. Okay, so the tenant will hear it, or you guys will hear it referred to as a stipulation. Now, if both parties can't come to an agreement, because both parties do have to agree on the stipulation before anyone signs it, right? So the landlord can't just say, I want you to pay in 3 weeks, sign this document. If the tenant doesn't agree to that, or it's not realistic for the tenant, they don't have to agree. Both parties have to agree before the stipulation is signed. But if both parties go back and forth and there's no agreement that can be made and no one is kind of willing to budge, usually the case will move to a trial part, which can be a bit tough, especially if the tenant is unrepresented. So usually we suggest before the tenant decides to take their case to trial, maybe speaking to an attorney just to get some advice about, how this works to be able to make an informed decision. The case also could be dismissed, right? So if the landlord made any mistakes, right? Let's say the landlord didn't give the tenant that 14-day rent demand before taking them to court, the case can possibly be dismissed. So if the landlord didn't follow all the proper procedures, the judge can dismiss the case. Or the case can also be discontinued. So in that first example that we mentioned, if the tenant has paid everything by the time the landlord has taken them to court, they can request a discontinuance and the landlord can drop the case, or the judge can dismiss the case, or discontinue the case rather, sorry. The other type of outcome is an adjournment, which, as we mentioned in the beginning, usually that first adjournment is automatic. And then if the tenant is not ready on their next court date, or they need more time for something, they can ask to adjourn the case, or the attorney can ask to adjourn the case. This just means that they're asking to move the case to a later date. And the last type of outcome would be a default judgment, which the tenant wants to avoid at all costs. But this basically means, let's say the tenant has their court date and they don't appear, the landlord can ask for a default judgment and the judge can grant that to them. Okay, so the tenant wants to avoid a default judgment at all costs. Now we're going to get into stipulations a little bit. So stipulations is definitely something that is on a case-by-case basis, but most of the time in a non-payment case, the stipulations will state some pretty basic stuff. So usually the first thing that the stip will say is, again, how much is owed, right? So once there is an agreement on how much is owed, there's no dispute about that. The stipulation will state the amount, and then it will state when the amount has to be paid by. The stipulation will also state if that amount is not paid by that date, what will happen. Also, if there are any repair issues in the apartment, if that's the reason the tenant wasn't paying, or even if that's not the reason the tenant wasn't paying, if they raise the defense that there's repair issues in the apartment, the judge can give in part of the stipulation a time frame on which the repairs have to be paid by. The repairs have to be done by. And when the tenant has to provide access so that the landlord's people can come in and do the repairs. So that is also something that can be stated in the stipulation. Now, again, also, the stipulation is on a case-by-case basis. Everyone has different situations. So there can also be some other stuff mentioned in the stipulation, such as if that tenant is, let's say, a rent stabilized tenant and the landlord has not given them a new lease renewal, the stipulation can state when they have to receive that new lease by and when they have to sign that new lease by. Another factor of the stipulation can be if there's any subsidy documents that need to be completed or signed. So a recertification document that needs to be completed. A time frame can be stated in the stipulation. If there is any harassment being done by the landlord to the tenant or the tenant to anyone else, that can be stated in the stipulation. And then as well as if that tenant is applying for rental assistance, that will be stated in the stipulation. So it can say something like, the tenant has to pay this by this date and they are to apply for the one-shot deal, right? So it can state what resource they are working with to get the arrears paid by. Now, usually the end of a non-payment case can end in a couple different ways. So as we talked about before, that default judgment, right? There's also other judgments. So there can be a money judgment, there can be a possessory judgment. But basically what that means is that a possessory judgment means that the landlord has the ability to hire the marshal. The marshals can serve the tenant that 14-day notice, and they are now at risk for eviction. A money judgment is usually where it's about the money, right? So the tenant, they now have a judgment where they can collect on legal fees or anything else that they're asking for, in whichever way that they see fit. Now, usually in that non-payment case, if you pay what was agreed upon that you owed, that judgment can go away, but it is important for that tenant to make sure that that judgment was vacated or satisfied. Okay, because in that public record of the case, it can say that the judgment has been satisfied, which is what the tenant wants in their favor. Again, as we mentioned, that possessory judgment usually gives the landlord permission to hire the marshal, apply for the warrant. Marshal can come to the apartment and they can either carry out the eviction if the tenant never responded, or serve the 14-day notice and the tenant has to respond to that notice. Now, as far as marshal's notices, again, they are usually served by either a marshal or a sheriff. But usually how that works is that they first come by to give the tenant, it's a 14-day marshal's notice. Now, it's very important that when the tenant gets a 14-day marshal's notice, they go to the court to respond as soon as possible. A lot of the time, tenants get this notice and they're like, oh, I didn't know what to do. And if the tenant doesn't respond in those 14 days, the marshals will come back to carry out the eviction. So on the eviction notice, which I think we'll take a look at in the next slide, but on the eviction notice or the marshal's notice, it will have what's called the earliest eviction date, which is extremely important for the tenant to know because that lets them know when the marshals can come back to perform the eviction, right? So it's the earliest day that legally the marshals can come to evict. Now, if the tenants do get a marshal's notice for any reason, they are able to put a stop to it as long as it's within that 14-day time window, and they would be coming to the court to file what is called an order to show cause. Now, as Angela mentioned in the beginning, we are able to assist with some of the forms that the tenants have to file. So if the tenant gets a marshal's notice, they can come to court, they can get the order to show cause form, and we are able to assist them in filling that form out, or at least guide them on how to do so. Okay, and the tenants will also hear referred to as an OSC. So this right here is an example of what a marshal's notice would look like. Again, a few important identifying factors. Again, it will have the index number at the top. So that's very important to identify because if you call the marshal, if you call us, if you call the court, they're all going to ask what's the index number or what's the marshal's docket number, which is also here as well. It's also important to check here. This is usually called the caption. So it will always say, who's starting the case and who the case is against. So the tenant or a relative of the tenant, whoever the case is against, it will state it here. Sometimes there are mistakes made on the marshal's notices, which is important to let the court know. So just make sure all the information, is right. And then here is another important part of the marshal's notice to identify because it explains who the marshal is and it has their phone number. So if you want to call the marshals to ask them any question, if you want to ask them, hey, when was the marshal's notice served? If you want to ask them, hey, when is the scheduled eviction date? Any of those questions, you can just really quickly call the marshal, give the index, and they can give you that information. Here at the bottom is another identifying factor, which is the date of notice and the earliest eviction date. So the date of notice will be the date in which the marshal served this notice to the tenant. And that earliest eviction date is the date that we were talking about in which legally they can come to evict. Now, the scheduled eviction date and the earliest eviction date sometimes are different because the marshals do make their own schedule. So sometimes the tenant is scheduled for eviction a few days after the earliest eviction date. Again, the earliest eviction date states the earliest day that legally they can be evicted. The eviction can take place a couple days after, the day after, any time frame after. So it's always important to call the marshal to see if they have a scheduled eviction date as well. Now, as we mentioned before, if the tenants do get a marshal's notice, they are able to do that order to show cause, which basically they are requesting a court date from the court to explain that they need more time or explain if they have already paid, whatever they would like to tell the court, but that's what the purpose of the order to show cause is. If their order to show cause is approved, usually what will happen is the judge will give another court date, and usually either determine if the tenant is going to get more time, if a new agreement is going to be made, they'll determine what's going to happen going forward. And usually the tenants will get 3 copies of the approval. One will be for them to keep, one will be for the marshal to be notified that the judge, gave them that court date, gave them more time. And once the marshals have been notified, they then know to cancel the eviction. Again, some courts do it a little different. Some courts will serve the marshal for the tenant via NYSEF, that electronic filing system. And some courts will make the tenant serve the marshal on their own, which they give them instructions on how to do that. And then the last copy that they get is for the landlord to inform them that they also have a court date. Okay, so you guys are going to hear me stop talking for a while, and Angie is going to go over the details of a holdover case, which is the complete opposite of a non-payment.
Okay, great. Thank you, Adriana. So holdover cases different from non-payment, a type of eviction case, but the goal is for the landlord to get the apartment back. So they're not starting the case because they want rent money back, although they can include it in the petition. The goal is to get repossession of the apartment. So something other than the rent is the issue. Tenants are allowed to raise defenses, which are the reasons why they should not be evicted. But the outcome of a holdover case will very much depend on the type of housing that the tenant lives in. This will determine their rights and their legal grounds. So whether they have good cause eviction rights will really determine how one should navigate this case. So, for example, tenants who are rent regulated, rent controlled, rent stabilized, NYCHA have good cause evictions rights. And as of last year, it's been almost a year now. Now tenants in market rate apartments, some tenants, not all of them, have good cause eviction rights as well. They are covered by the new good cause eviction law. Some, again, not all market rate tenants. And by market rate, I just mean anyone that's not rent regulated. Okay, so the notices and the papers for a case. Similar to the non-payment, something has to come before the actual petition itself is filed and served. This is called a predicate notice, which must be served either 30, 60, the tenant must be given 30, 60, or 90 days to vacate before a landlord is able to actually open up a case with an index number. It depends on how long the tenant has lived in the apartment. If they get a 30-day notice, that means they've been there for at least 30 days, but less than a year. 60 days would mean they hit the 1-year mark. and 90 days would mean that they've been there for over 2 years. Service rules are complicated, but they must be correct. So if a landlord screws up service, yes, it can be brought up as a defense by the tenant, but it doesn't mean that the tenant should ignore the court papers. Sometimes I think tenants get a little bit hyper fixated, and they are right in the sense that they're not served correctly, and they should definitely bring it up as a defense, but it might not stop the case altogether. So what they should receive are the petition and the notice of petition after they've gotten the predicate notice and that time has elapsed. How long that takes really depends on how quickly the landlord moves. Um, they must be served on the tenants according to the rules of service, just like the predicate notice. It's very similar. It's pretty much the same thing. And for a holdover case, the notice of petition, unlike the non-payment case, will actually include the first court date with the date and the time and the place of the hearing. So for the non-payment, you have to answer to get that first court date. For the holdover case, it actually comes with that first court date. Service of court papers. So there are many ways in which a tenant can be served or delivered the papers. The first is personal delivery, which is handing it to the tenant. It cannot be on Sundays or on religious holidays, and it must be between 6 a.m. and 10 p.m. There must be two separate attempts. Two attempts can be 2 different days or one day, but at two different times. There's substituted service, which means that the papers are handed to somebody else who is of a suitable age and discretion in the apartment. There's also conspicuous delivery, so if they're not able to find the tenant in their home or anyone at the home, a copy can be posted to the door, and then a copy has to be mailed by certified and regular mail the following day. Service must be done by somebody other than the landlord. So the landlord cannot be the one serving these papers to the tenant. It can be a process server or a friend or relative, anyone that is not a party to the case. And whoever serves the tenant has to fill out an affidavit of service detailing how the service was done, and it must be completed and filed with the court. I believe within 3 days, you have to come back if you're the landlord filing it and show the court the affidavit of service. Again, proper service is important, but tenants shouldn't pin all of their hopes on defeating a case just because there was improper service. So tenants need to pay very close attention to the grounds for the case, which we're going to talk about next, and what is allowed and what is not based on their specific housing type and situation. So grounds. There's a no grounds holdover, for example. This is for unregulated apartments where there is no good cause eviction coverage. Perhaps there's no current lease. Perhaps they're a month-to-month tenant. So these are the types of cases that are kind of straightforward. It really is just about time given to the tenant to vacate the premises. If the tenant has a current lease, it's still active, the landlord needs to have a good cause to start an eviction case. And if the apartment is regulated or covered by good cause eviction, the landlord also needs a good cause to end that tenant's tenancy because, as many of you may know, for rent regulated tenants, the landlord is required to provide a lease renewal every year or 2 years, depending on what lease was signed last. So for good cause eviction in unregulated apartments, we haven't really seen these cases play out too much in court. What has changed is that now landlords have to tell a tenant whether their market rate apartment, and this does tend to be private homes, is covered by good cause eviction or not. And the general rule of thumb is if the landlord owns more than 11 units in the state of New York, then that unregulated apartment, which previously wasn't protected by good cause, now is. And so now the landlord, in order to start a case, has to have a good reason to do so. Good cause also caps rent increases, cannot be increased by 8%. What gets tricky with good cause is it's hard to figure out if a landlord owns more than 11 units. Many landlords are corporations or a number of people who own certain properties. And I think we're still figuring out the kinks on how to figure this out at Housing Court Answers. So we're definitely open to other folks, how they're navigating this. But yes, that is new paperwork that tenants are being shown now. The predicate notice and the petition papers now include good cause eviction forms. And there's a checkbox, no or yes, as to whether their apartment is covered by good cause. Okay. In unregulated apartments, when a tenant has no lease or an expired lease and the tenant is not protected by new good cause eviction laws, the tenant is entitled to a notice of termination. So that's the 30, 60, or 90-day notice, depending on how long they've been there. And like I explained previously, under a year, 30 days, 1 to 2 years, 60 days notice, 2 years and up, 90-day notice. So really, these cases, there's not protection from rent regulation, there's not protection from good cause. It really is just a matter of time, and there are ways to get more time for a tenant to vacate. But this is why it's so important to get a good understanding of what type of housing the tenant lives in, because that'll help you to better explain to your tenant how they have to navigate their case. What is it that we're working with? Because possibly for a rent regulated tenant, the goal may be to prove, hey, actually, the landlord doesn't have a right to end my tenancy. Whereas with a tenant that's not really protected by much, it is just a matter of time because the landlord does have the right to end the tenancy. Good cause. So, what counts as good cause? There's a number of things that fall under good cause. Tenants in rent-regulated or subsidized apartment or covered by the good cause eviction law are protected from eviction without good cause. So violating the lease, for example, might be a reason that's stated. And these things could be curable. The tenant can fix it. So, for example, maybe a tenant has a pet and the lease indicated that there was not supposed to be a pet. Maybe there's a washing machine. So there might be some room here for the tenant to actually correct the behavior. They might be violating the law in that maybe they're selling drugs or there's other illegal activity or the apartment is being used as a business as opposed to a residence. Nuisance is a common one that we hear about all the time. Hoarding, violence, fires, flooding is one we hear about a lot as well. Some folks are in housing through a program or they have a voucher. So perhaps they're violating the rules of the program. So for example, maybe that apartment is not their primary residence. If they have Section 8, do they have folks in the apartment that are not supposed to be there because they weren't reported on the voucher? Perhaps they haven't recertified. Some apartments, like HUD buildings and NYCHA, require you to recertify every year because you're reporting your income to figure out what your rent is supposed to be. Not paying the rent is an obvious one that could be a reason. And other avenues in the laws, landlord's personal use, demolition of a building, for example. Who is not covered by good cause eviction? I think this is the most straightforward way to understand who good cause is benefiting. So again, like I discussed earlier, a landlord that has 10, 10 units or less, because they have to have 11 or more for it to be covered by good cause. And it could also be a building with 10 or fewer apartments that are owner occupied. Apartments owned by small landlords, so when they own 10 or less units, that is a small landlord. And again, this can be kind of hard to figure out. We're still trying to figure this out as well. Apartments subject to rent stabilization control or a federal, state, or city subsidy program are not covered by good cause eviction because they already have protections. Apartments are condos or co-ops or exist in a condo or co-op building are not covered by good cause. Apartment that is owned by a hospital, university, dorm, church, or other nonprofit is not covered by good cause. If the rent is super high, like $6,000 a month, that is not covered by good cause. And any building built after 2009 is not covered by good cause. A good way to kind of get an idea, I think, as to whether a building or an apartment might be is definitely the date it was built. And we do have a number of tools to sort of figure this out. If you guys aren't familiar with Who Owns What or Just Fix, those are great tools to figure out the history of a building. I think rent stabilization became a law in like the 70s. And so buildings usually built before then that have 6 units or more can be rent stabilized. Private homes tend to be unregulated. So that's my general rule of thumb. I like to look at the date in which a building was made. Um, and then I like to ask my tenants, like, how many units are there in the building? Is it 6 or less? That gives me a good idea as well.
Okay, so now we are going to go through HP actions. So HP actions, there are a couple different types. Well, technically there's two types and then there's a combo, but essentially what an HP action stands for is housing part. A lot of people have that question. But essentially what it is this is a case that is filed by the tenant or could be filed by HPD, or it can also be filed by a group of tenants. So completely different from the holdover we just talked about, the non-payment we just talked about. The HP action is filed by the tenant or by a group of tenants or by HPD. And this case is strictly going to be about repairs or harassment. So there is an HP action, again, strictly for repairs, if that's the only issue the tenant is having. There is a HP action for harassment, if that's the only issue the tenant is having. And then if the tenant is having both issues, there's repairs needed in the apartment and they feel that there's harassment from their landlord or management company, they can do the combination HP action. Usually with this HP action is going to involve any existing violations. So if that tenant has already had an inspection done by 311, and they, have had continuous inspections done, they can use that. Or the court, as part of the process, usually schedules a inspector to come and issue those violations so that it can be reported for the case. Usually the outcome of this case, a lot of the time the tenant wants compensation, or if their belongings were damaged. Unfortunately, that's not what the HP action case is for. The purpose of this case is to get those repairs fixed. If that tenant has any damages, or they want compensation because of the conditions of their home, that's usually something we would divert to the civil court. But essentially for this case, it's going to be about either restoring the services, so that's like heat and hot water, if the tenant has none of that, or if there's repair issues, getting those repairs fixed, or again, if it's about harassment, getting that harassment to stop. So this case is about remedying the issue. There's also another case which is called an illegal lockout. And so essentially what an illegal lockout case is if an illegal eviction has taken place, meaning the landlord has illegally changed the locks to the apartment, or if it's a tenant to tenant issue, which a lot of the time the illegal lockouts are, usually it's, the tenant is living with another tenant. That tenant has changed the locks. That other tenant can no longer get into their apartment. That would be a classic illegal lockout. Again, usually a legal eviction, as we talked about, would be if the marshals had gotten involved, and the marshals only act based off of court orders. So if the marshals evicted based on a court order, that is a legal eviction. If there were no court papers filed, if there was no marshal's notice and the tenant was evicted, that is illegal. Okay. Again, also cutting off essential services on purpose can also be considered to be illegal lockouts. So if the landlord has cut off electricity to the tenant's apartment, they can also file an illegal lockout. So that also counts as that. Now, for the illegal lockout, usually because the tenant is out of their apartment, the police sometimes can assist. They have the power to jump in, but sometimes they would prefer for the tenant to go through housing court. Sometimes they say this is a housing court issue. So the tenant can call the police, and sometimes that does work. The police can request documentation from the tenant to prove that they live there, and they can facilitate the tenant getting back in with the landlord. But if that is not something that the police are assisting with, the tenant can come straight to the housing court. They can file the illegal lockout papers. And if the judge issues for the tenant to get back in, that is a court ordered thing that they get. And so the tenant can take that court order and it is enforceable by the police. So if they have a court order stating that they are to be given access to the apartment and the landlord or the prime tenant is still not giving them access, again, at this point, they can call the police and the police are supposed to intervene because that is a court order. Okay. The judge can also issue any damages or fines. So, because again, this is illegal, but the tenant would definitely have to ask for that within this illegal lockout case. And then there are other types of evictions. There are evictions that can be performed by the sheriff, or there are evictions that can be performed as a result from civil court or foreclosures or Supreme Court, but those are within the other courts. So, we definitely would direct tenants to those other courts if those are the issues that they're having. And then the Supreme Courts in each borough have help centers. So if the tenants have questions on that Supreme Court process, they can contact the help centers, which if that's something you guys need, we can drop the link in the chat to the help centers and their phone numbers so that the tenants have that as a resource as well. And then Angie is going to now talk about the rental assistance that tenants can get assistance with.
Great. And I did answer some of those questions as Adriana was speaking. If they're cutting the heat, that's not an illegal lockout because you haven't been locked out of the apartment. So you would start an HP action for repairs to get that done. Somebody asked a really great question, Adriana. I don't know if you want to answer it now or at the end, but they said, do holdover cases apply to private homes when the homeowner is illegally renting out the basement? And this is like a double-edged one because there are landlords that do start cases to remove their tenants because technically they also can't remove them from the apartment if they've been there for more than 30 days. But I think maybe that one, if you want to answer it now or at the end, because I feel like there's different sides to that.
There's definitely different sides. So if this landlord is illegally renting out the space and they're trying to evict the tenant, that is something that they can bring up as a defense. Supposedly, I mean, I know when it comes to rent, they can't sue the tenant for rent if the space is illegal or it's not registered. I'm not sure how that would hold up if the tenant is being evicted. Because another kind of edge sword to that is if the space is illegal and it's deemed unlivable by, let's say, HPD or 311, they can issue a vacate order anyway, which would mean that the tenant still would have to leave the apartment. So that kind of is a double-edged sword type of situation. But it is a defense that they can bring up in court, but it's kind of something that we would suggest maybe getting advice on about how to bring it up or when, because again, that vacate order can be worse than a holdover.
Yeah, because with the vacate orders, you don't really get time.
Yeah.
And vacate orders are a little interesting too, because I feel like sometimes they put the order and then no one ever comes to actually remove the tenant.
Okay.
Sometimes they come and they do. And they're put in a hotel. I think the Red Cross takes over at that point to put the tenant in a hotel. But that could be worse, than not saying anything at all. So I think the tenant at that point might need some legal advice to see how they would best navigate that. But yes, let's get started with getting help with the back rent. It's a big thing that we do here at Housing Court Answers. We don't have funding. We wish we did. But we do referrals to other organizations that have funding with the back rent. And for those of you who are not familiar, the main rental assistance program that the city offers is called the one-shot deal. It's meant to help folks catch up with their rent by paying the back rent. It is a loan that you have to apply to through HRA. HRA does many things like offer Medicaid, food stamps, all sorts of public benefits. And they also oversee the one-shot deal. So they make the decision on that. The one-shot deal is for the most part a loan, but there are circumstances where they will step in as a grant where the tenant doesn't have to pay it back, but that very much depends on the worker that you get. It is their decision whether they want to give you the grant or not. Um, and another type of assistance that you can get at the same time that you apply for the one-shot deal is cash assistance. This is ongoing public assistance payments. It can be for shelter or other costs. But the thing is that getting cash assistance is not necessarily a solution to getting help with the back rent. It can help some, but it's more so a tool to get other programs that might help you with the rent. So for both the one-shot deal and cash assistance, you can apply using the Access HRA app, or you can go to a local HRA center. And you guys should know, and maybe a lot of you do know, it is a slow process. So I do implore you guys to tell your clients to stay on top of it, to get updates, see what's going on with the one shot. I think where a lot of folks, I don't want to say mess up because I don't want to say it's their fault, right? But I feel like they think that these agencies might be more communicative than they actually are. They might open a case and then months go by. They don't know what's going on. And then we get the call, oh, I filed or I applied months ago and they haven't reached out to me. You really need to encourage the tenant to be proactive and to ask questions, to speak to a supervisor. There are also HRA offices at every housing court. So if they don't want to go to a center, while they can't open an application at the housing court, they can get updates there. And we also have someone who can look into a public assistance case to get an idea as to what's going on. So yes, and I'm going to post in the chat the link to the Access HRA website to apply for the one-shot deal and cash assistance. And then I'm also going to put a link to help your tenants find their local HRA center. It does go by zip code. So you can't just go to any center. It has to be the one that you are designated to. Okay, great. So I was talking a little bit about how cash assistance can be an avenue to getting other types of assistance because cash assistance is really not that much. Folks do not get that much every month from it, maybe like $80 from what I've seen, twice a month, something like that. That's not really enough to pay the rent. But what it can help you qualify for is FEPS. FEPS is a housing voucher, and it's meant for folks who have children under the age of 18 in the home. It helps with ongoing rental assistance, but they can also cover a portion of the back rent to stay in an apartment that is at risk of eviction, or the voucher can be used to look for another apartment. And so people can apply for FEPS in a non-payment and a holdover, but remember, for the holdover, there's no guarantee you're going to stay in the apartment. So in this situation, it might be that you're using FEPS to move out rather than to stay in that apartment if it's a holdover case. The other type of assistance, also voucher, is city FEPS. So different from FEPS in that it's not intended for families with children. It's intended for single adults who have been in a homeless shelter in the past. And it does have to be a DHS shelter. So they do offer city FEPS for folks who are already in the shelter. But if folks find themselves in housing court and they've been in the shelter before, they can try reaching out to Homebase to see if they can get this voucher. Getting an appointment with Homebase can take some time. So we do tell folks, Homebase can offer so many resources, but at the same time, it might not be the immediate solution. It might be something that you can tap into towards the end of a case when something is more of an emergency. I feel like there's a lot of misinformation with vouchers where folks think you can just call and get one. Again, you do have to have shelter history. You do have to have a case in housing court. And Home Base, for those of you who don't know, is a network of nonprofits in New York City neighborhoods which provide homelessness prevention services, and they do oversee the City FEPS voucher as well. Home Base, for example, Canva, Catholic Charities are examples of home bases, and they are zip code based as well. We also understand that certain home bases can also offer some rental assistance as well. We've seen it. For example, Catholic Charities can sometimes cover a month or two of rent. What I've heard as of late is if folks owe 3 months or less, Catholic Charities can step in at that point. But if it's more, then they won't. Okay. So private charities are another way of getting assistance. And sometimes, well, most of the time, what folks do, not only do they apply for the one-shot deal, but they also reach out to private charities. And the good thing about that is that you can do both at the same time. You can get assistance from multiple places. And the charities don't require for anything to be paid back. So a tenant can lower the debt so that they take out a smaller loan from the one-shot deal. Undocumented tenants can get assistance from some private charities or social service organizations, but not all. We do recommend that maybe you direct your tenants to us and we can do a run through as to what charities they could apply to. Organizations offering rental arrears assistance do not always require tenants to be in court, but some of them do, and that's something to keep in mind. They can also sometimes help with utilities or moving expenses, but it's usually not a lot of money. I know Nazareth Housing has a department for furniture, for example. So yes, we do recommend that you refer your tenants to us. We do rental screenings over the phone and in person. We ask questions about income, like what's going on with the rent, how much is the rent, how much do you owe, to get an idea as to what charities could best help you, because many of them will only serve certain boroughs. And getting help in court. So what can your clients access in the court? Well, they can access us. We're there again Monday to Thursday from 9 to 5. Each county's housing court also has a help center, and it does have a pro se attorney staff where they can ask legal questions. We also have a legal advice hotline for folks who are in court and who are not that we can transfer them to. Interpreters are also available to any litigant. So it is a tenant's right to be able to access an interpreter. Some languages are available on a daily basis, for example, Spanish, but some must be scheduled. So yes, you can put that request in with the clerk. Every court has a clerk's office and they can offer basic directions and the forms. Most of the forms that you would get would be with a clerk. Once again, we do have tables staffed at every housing court, with the exception of Staten Island. So we can help your tenants get an idea as to how to fill out an order to show cause, understand where they're at in their case. Even though we can't offer legal advice, I feel like we have so much experience seeing these cases play out from beginning to end that we can give folks an idea as to how their case might play out, strategies to use. We never tell them what to do because we can't. But we can definitely offer resources. Yes.
Okay, so believe it or not, all of this information was general. The housing court, as you guys can see, is extremely complex. There's so many things that plays a factor into a tenant's case, different cases in the court. So because of all of this information, Housing Court Answers does have a new training series. So this workshop is super kind of detailed, geared towards the housing advocates to be able to help your clients. But if your clients would like this information directly, we have workshops geared specifically for the tenants. So we have legal information broken down. For example, the HP action, we just grazed over what an HP action is. We have a full workshop just talking about how to fill out the forms for an HP action, what happens from start to finish. Same thing for non-payment and holdover cases. So if you guys would like your tenants to have this information directly, this link here, housingcourtanswers.org/AHTP, you can find the calendar to the different topics that we do and on which days. So we do about 2 to 3 workshops every single day, Monday through Friday. They are on Zoom. So if a tenant wants to join the workshop to learn about what's going on in their case at that moment, we do have a schedule on a weekly rotation for these topics. We do have these topics as of right now available in both Spanish and English. Not all the topics are in Spanish, but most of them are. If you guys would like to schedule an in-person workshop with your clients, so we know spaces like HRA, even some of the home bases, there's a long wait time. So if you would like to schedule an in-person workshop with us, we can talk to your clients while they're waiting to talk to you guys. Or you guys can gather, whatever tenants that you guys know need this information, and we can do something in person. You can send me an email at adriyanat@housingcourtanswers.org. That is that first or the last email here at the bottom. Or you can send my colleague an email, that's Sarah L. at hcanswers.org. If any of you need that typed in the chat, we can do that as well. But we would be more than happy to come out to any location that you guys have to do one of these workshops in person. We do also have this flyer that is printable. So we do give these out in the housing court. If you guys would like these flyers to be sent to you guys so that you can give them out to your clients or any other agencies that you know would like them, please let us know. We can send you guys a box of these flyers, or we can send you the flyers digitally that can be printed out. Okay. So that comes to the end of our workshop or training today. I know there were some questions that we already answered in the chat, but if there's any questions that you guys have now that you guys would like to ask, please let us know here in the chat. We can definitely do so.
Yes, we're going to be
I see,
sending, I think NEPA might be sending the PowerPoint.
or it might be on the website, I think, right, Nipa? If we give you the
Yeah,
link.
we're gonna post it on the website and I can post the link to our website where it should be posted on the chat.
Great, great, great. So we have a box of flyers would like to be sent to this org. Wonderful. So we'll take that down and I will shoot you an email. Awesome. Yeah, email. Okay, awesome. If you guys, like I said, if you guys have any questions, please feel free to drop them in the chat. I know we probably answered all the questions as we were presenting. But if you guys have any more, please let us know.
It looks like folks want to get the flyers. Yes. Should we jot this down, Adriana? Everyone
I was
wants
about to ask Nipa, do we get a transcription of the Zoom chat?
I'm not sure, so I would jot it down.
Okay, so I'll jot it down. If you guys do need to reach, again, either one of us, this here is our hotline phone number. So if you guys would like to give them to your clients, if you guys want to call us for arrears assistance, that is our hotline phone number. And then the emails, if you want to set up an in-person workshop, was in the chat as well.
Oh my God, please invite us. Please.
Yes, please. Please. We want to come out and talk to people. It's so much better than talking on Zoom. We prefer it. While I take this information down, Angie, I think there was one question here about a
Yes, I
holdover.
see a question, and I definitely invite you guys to jot down, if anything, housingcourtanswers.org/AHTP. That is where all of our virtual workshops exist. That's where the link is to the Zoom. Anyone can attend it. Yeah, and it's just a great way to get all of this information out to tenants. So the question, in a holdover case, after the intake day, how soon should the tenant file an answer? They don't necessarily need to file an answer. It's not necessary. Is there a deadline by which I think before the following court date is when you should submit an answer if you are going to do so. It's great for cases I think where you're going to try to contest the holdover itself. But it's not necessary. But I do find that it tends to be tenants who feel like the holdover is unjustly being started that they file a case. We can kind of give folks like a guideline of maybe what they would like to write, but we don't write it for tenants. You can write it alongside them. But again, we're not attorneys, so we can't give legal advice. Yes. Do we have any other questions? That was so much information. I don't see any other questions. I would like to reiterate that we really are trying to extend our network by doing these in-person workshops with other folks like yourselves. I feel like we all do such similar work, but every organization is like missing a piece of the puzzle because we focus on certain things, right? So like, for example, I would love to know about how Homebase navigates things. That might help me to better direct my tenants when they're looking for resources. In the past couple of weeks, there have been organizations that have reached out with new rental assistance programs, new services that they offer. So we're definitely interested in visiting you guys and trying to form these relationships because I think it would make it so much easier for tenants to be able to access things, you know, like maybe we might learn, okay, Riseboro does this, like that's a good place that we could direct the tenant to. Or maybe NICA is really good at doing this, or NICA could learn, you know, like Housing Court Answers does rental arrears assistance. We're going to send our tenants over there. So I think our goal is really to just create that city network to help tenants navigate their cases, particularly the ones that are unrepresented and doing this on their own. So yeah, we
And I
definitely
think
do.
NEPA, I don't know, correct me if I'm wrong, I'm a little out of touch with the spring trainings. I think that we have more of trainings coming up for the spring, right, with other agencies. So if you all would like to give a workshop with Housing Court Answers on a specific topic, I think who would they reach out to if they would like to do that, NEPA? Oh, NEPA, I think you're muted, NEPA.
Yeah, maybe they could reach out to Jessica. I can post her. Yeah, I would say just reach out to Jessica, or maybe just call us on the hotline and let us know that you want to do a training, and we can see what the availability is.
Yep. And I don't know, do we have another training coming up for the spring or not yet?
So our next trainings, we have a couple of them trainings posted. So the next one will be Wednesday, March 12th, which is rent arrears and one-shot deals. Super important in the, housing world, especially with back rents. But I'm gonna post the link on the website, which has some of the trainings that you can sign up for already. We also have a rental assistance and packaging cases with the Bridge Fund, benefits series, eligibility for FHEPS in the community on March 19th, a benefit series, eligibility for city FHEPS in the community on March 26th. So those are a couple of them that are posted, and there should be more posted soon. But feel free to sign up, and I put the link in the chat so you guys can sign up for those trainings.
Awesome. Thank you so much, NEPA.
Of
And to
course.
NEPA handling our tech today, thank you so much. We appreciate you. If you all don't have any more questions, we do appreciate you all for joining us today. Again, like Angie said, we do want to, keep that connection of resources available for our tenants. So please feel free to reach out to any of us if you all need anything. We do get calls from agencies on behalf of their tenants. So please feel free to give us a call or shoot us an email. Again, our email should be in the chat. But again, we thank you so much for joining us today, and we do hope you all join us again for more of our workshops, and you all have a great rest of your Friday evening.
Did we jot down all of the emails? I think we did, right? Yeah. Just gonna take a screenshot.